All right, welcome back, viewers, to another episode of Ask Johnny D. I'm John DeGasperis. My friends call me the PI guy. In this episode, we received 4 legal questions, and you're about to get my answers. Thank you for participating. Here we go with question number 1. This one comes from Katie in Providence, Rhode Island. Katie asked 2 questions. They're related. She wants to know, what is the statute of limitations for the torment caused to a younger sister by an older brother? And what type of compensation could one receive for the emotional stress caused by this older brother? Well, let me tell you, if you were lucky enough to have an older brother like me, I doubt that there's much emotional trauma caused by many years of joyful play. But if you were bullied by your older brother, you don't have any legal cause of action. See, children cannot be held accountable if they're under the age of 4. This is New York law. An infant under the age of 4 cannot perceive danger and thus cannot be held negligent. Now, for any child over the age of 4, we are not going to use the normal reasonable person standard. That's typically how we determine whether someone acted negligently. What would a reasonable person do if presented with the same facts and circumstances? With a child, we are going to hold the child accountable based on a standard of other children with the same years, experience, intelligence, and education. So, I don't think you have much in terms of legal causes of action against your brother. Now, what about your parents? Can you go after your parents for failing to supervise your brother? The answer again is no. You cannot hold parents accountable for the negligent acts of their children. That's New York law. There's only one exception. That's if the child uses a dangerous instrument, and it's pretty hard to find a dangerous instrument. It's got to be something like a gun or a chainsaw. A bike, a scooter, that won't qualify. Now, as for the statute of limitations, general negligence causes of action in New York are governed by a 3-year statute of limitations. But if you were a child when you suffered the injury, your statute of limitations would be told during the entire period of infancy, and then you get 3 years from the date you reach the age of maturity, which is 18. So Katie, thanks for submitting your question. I hope that you and your brother now have a very good and close relationship. I know I have a great relationship with my sister, but I was always really good to her when she was a kid. Question number 2 comes from Risa. Risa, thank you for your question. Risa asks, how can you prove that you got coronavirus from a doctor's office? This is a good question. Now, I recently posted my feelings about coronavirus cases. I don't think they're going to be good cases. I'm never taking one. You have my word. Why? Well, Governor Cuomo is giving immunity to healthcare workers who are responding to this healthcare crisis, as he describes it. And in addition, I question whether juries will want to hold healthcare professionals accountable for the care that they're providing in this new world, this new dynamic, and with respect to a virus that we know nothing about. Now, Risa, you ask a very good question. How do you prove you got coronavirus from a doctor's office or some other type of healthcare facility? And this also is a difficult question to answer. It's another reason why coronavirus negligence cases are garbage. You need an expert. You have to be able to prove your case. You're the plaintiff. You have the burden of proof. You must be able to prove that you contracted the virus wherever it is that you allege you contracted it. So if you think you got it at a doctor's office, you have to prove it. This is undoubtedly going to require expert analysis. You're going to have to hire an expert to opine within a reasonable degree of certainty that you contracted coronavirus at the place where it is that you allege you got it. This is going to be difficult. This touches upon both the issues of negligence, whether or not the defendant or tortfeasor breached his or her duty of care. I think it's also an issue about causation. Did the alleged negligence cause you to contract coronavirus, these are not going to be good cases. Don't pursue them. They're garbage. This is question number 3. Question number 3 comes from one of my biggest fans, Jenna. Jenna wants to know, are Jay and Kristin getting back together, and if so, when? All right, listen, I get that there's been a lot of hype on Instagram lately because this couple, they've been together for 10 years. They posted a picture together about 9 months after their divorce or separation, and everybody's speculating, are Jay and Kristin getting back together? I don't think so. I did my research, Jenna. I think that these two are in it together to raise 3 beautiful children. They know they got a co-parent, so they're being civil, but I think that this relationship has definitely run its course, and this is probably good for the NFL because with the Bears' 8-8 record, I think Jay Cutler should study the field a little more. Okay, question number 4 comes from Teresa of Kingston. Teresa, thanks for your engagement, and I appreciate the question. It's on a very important topic, one of my favorite topics, medical malpractice. Teresa asks, is it negligent for a doctor to not treat a chronic heart condition because of some other comorbidity? Well, Teresa, I can't answer this question, not based on the limited facts that you gave me, but let me tell you how medical malpractice cases typically work. Medical malpractice is a deviation from accepted care. It is your job as the plaintiff to prove that the doctor who treated you deviated from normal conduct that would have been practiced by another doctor of average skill in the same community where your doctor treated. So again, what I have to prove as your lawyer is that the treating physician deviated from good and accepted standards of care. How do I do that? Well, I'm certainly not a doctor. I'm just a lowly old trial lawyer. What I do is I hire an expert, a doctor, a qualified physician, generally in the same specialty as the treating physician, and I submit the medical records and the facts to this reviewing physician, as I call them, at least initially. And this physician will look over all the facts and tell me whether or not the treating physician deviated from the standard of care. If I get the go-ahead from the treating physician, then I am permitted to pursue a malpractice case on your behalf, and that expert witness, that physician, will follow the case throughout and continuously be updated with respect to the facts that we learn. At the conclusion of the case, we usually have a battle of the experts, and let the best expert win. That's it for this week's episode of Ask Johnny D. Thank you for your participation. Thank you for watching. If you found this video to be entertaining or informative, consider giving it a like, maybe subscribe to my page. Otherwise, I'll see you next week with your legal questions, my answers. That's it from the PI Guy.